So I've just been through this simple liquidation process and what it could mean for creditors, business owners, directors, practitioners. Now, the second part of the reforms is something called the small business restructuring process. Now, the way I want you to think about it is there's a process, so it's this restructuring process, and then there's a restructuring plan. Now, most of what I'm going to talk about here is the restructuring process, and then we'll get to the plan a little bit later. But basically what the government has done here is they've said, look, let's have a look at the way the American system works. They've got this process called Chapter 11, debtor in possession type insolvency. So what that basically means is that a director, business owner, puts together a plan, applies to court to compromise their debts to their creditors or to do some type of workout or restructure, and then the court, I guess, either rubber stamps it or comes forward with what they think should happen. So the Australian process is slightly different. It doesn't really take too much from the American model other than, I guess, in form. Now, the Australian model is certainly about a director and business owner maintaining control through what will be a formal restructuring process. Now, we currently have an informal process where ASIC, there's no lodgements with ASIC, there's no formal appointee being an insolvency practitioner has to be appointed or anything like that. Now, what this is going to do is do what's like what we have currently in Australia is something called a voluntary administration. And the SV Partners website has heaps of details about what a voluntary administration process is. But effectively, it is a mechanism to allow you to compromise your debts or do a workout or some type of restructure with your creditors through a formal appointment. Now, this restructuring process is very similar to the VA, except on one point. Now, that one point is that in a traditional VA, the administrator, who is an insolvency practitioner, is the one to take control over everything. Okay, so they mandate everything, they consent, they dictate what happens, they report to creditors, they do all this work. Now, in this process, it's the director that pretty much does all of that. What I want you to think about here is you maintain control. It gives you the ability to restructure your affairs, to put forward offers through a formal appointment to your creditors, and it potentially protects your company from any litigation, potentially protects you as the director from any personal guarantees. And we'll come back to that because that's a very important point. And it potentially buys you more time. This restructuring process could be quite powerful depending on whether or not you can meet the eligibility requirements. And we're going to come to that in a short second. But I just want people to realize that this restructuring process is not really the American system. It's not really the voluntary administration process. It's control and power handed back to the director to do a formal restructure.